You are highly welcome, viewers. Thank you for always being on. Thank you for supporting us. And we urge you to subscribe, share the channel. This is the Legal Forum, as always. And we want you to, at the moment you see this content and you get addicted to this content, then it should be you to transfer or to share the content to other people so that they can receive the same message. So, without wasting much of the time, because we are time bad, and at YouTube we should not use a lot of minutes and hours talking about a topic. We should make it a little bit summarized so that we can get more time for covering other topics. For today, we are in criminal, or what we call the uh, criminal procedure. So for criminal procedure, this is the as I told you earlier, criminal procedure basically it deals with criminal processes besides civil. So for criminal, it talks about the crimes, how they are handled, they are tried, how the suspects are arrested, all that process. So it is combined and it is called the criminal procedure, the procedure for the crime. Now we have a topic: extradition. Extradition, and it is governed by the Extradition Act 124. So without wasting much of the time, extradition, this is the aspect of jurisdiction dealing with the process surrendering a fugitive offender from the surrendering country to the country where he committed the offense. Now, extradition simply means someone is being uh, surrendered or is requested to be surrendered from another country to the country where he committed the crime. So it means the country requesting is called the requesting country. So and the other country is called the surrendering country. So someone is in another country and is supposed to be tried in Uganda. So when Uganda is requesting for that person, then Uganda is requesting, and the country giving out that person is surrendering that person. So when you look at Section 2 of Extradition Act, it talks about uh, the application, who applies, and we shall see, and he applies through the minister and the parliament. Uh, So when you look at Section 4 again, it will talk about that Uganda is in commitment with other Commonwealth countries. They made that treaty or agreement that if any offender is in another country and it is needed, that person should be surrendered in good faith. So, because one of the principles that governs the international law is the principle of good faith. So, someone should be surrendered or should be requested on that good faith. So, section 1. Section 1, it gives some of the definition. Go and read section 1, you will see who is the minister, the powers of the minister, who is a fugitive criminal. So, but a fugitive criminal is that person who is the accused or convicted of an extradition crime within the jurisdiction of any other country who is suspected of being in Uganda. That person is suspected to be in Uganda, and being that is not in Uganda, is going to be extradited from that country to Uganda. That's what the act is saying about that. But uh, someone to be surrendered, there must be no the aspect of political for it should not be political in nature. What does it mean? That if someone is to be extradited, then the court, the magistrate, must sit and understand that if there is any political character, then that person should not be granted that order. The court should not issue that order that the person should be surrendered. So basically, go and read section 8. 8 talks about that, where the opinion for the minister is that the offense is of a political character, he or she may refuse to make that order to a fugitive to be discharged or not. So it is upon the court, the opinion of the court, to understand whether there is or not there is that character politically. So it is upon the court to make that analysis and give out the opinion. So the offense should not be political in nature. Section 3 and 8. Now, when you look at Section 28 of Extradition Act, for it explains the character of offenses that should be extradited. So now, have cases like murder, attempts, conspiracy, manslaughter, assault, abduction, rape. Very many. There are very many. When you read that section 28, it gives a little bit category or number of those cases that can be uh, allowed. And now let's look at the procedure. The procedure. So the procedure, how it is done. How it is done. But before that, I want you to understand that this works in, it is a reciprocal, whether the country requesting or the country surrendering. Anyway, when you find that Uganda is the one requesting or Uganda is requesting, so the act balances it all. So it tells you on how the foreign country is to surrender, or if Uganda is surrendering, or if Uganda is the one wanting or requesting. So you have to understand that, put it in your head. When you look at section 22, it talks about the requisition. Who requests? Because it is the minister to write to the magistrate to arrest. So the minister now is writing to the magistrate, and the magistrate must issue the warrant of arrest. But before that, you have to read the case of Castin, 1891. So in this case, they are telling us that someone participated in a political uprising in Switzerland and killed a government official. So the Court of England held that, being that the offense was political in nature, they refused the extradition. So they refused it because we said it should not be political in nature. That is section 8 clause 3. So you have to understand any claim that is political in nature, they should not allow, according to the number of cases stipulated under section 28 of the act. It shows the number of cases that should be allowed when extraditing someone. Then now section 24. For section 24, it talks about the foreign deposition statements and documents as evidence. So in this, the section allows the depositions, witness statements, warrant, and other judicial documents from a foreign country to be admitted. So here, they are meaning that when a foreign when a foreign country is, because when you look at section 24, when a foreign depositions, statements, and documents as evidence, which means this section allows deposition, witness, statements, warrant, and other judicial documents from a foreign country to be admitted as evidence in extradition process. So here, they are trying to mean that if the country is requesting for any person, then it should first document or group in the documents that talks about or that shows the number of witnesses, uh, the witnesses testifying that certain person, or the evidence relating to the same, yeah, relating to the to the facts or to the same case they are trying to impose on that exact person. So before Uganda surrendering that person, it must first receive those documents. Those documents talks about or have the number of witnesses, talking about the case and the evidence in simple terms. And section 25 talks about the judicial notice of documents. As you understand, that if you bring evidence in Uganda, then you must, at that time, carry what we call the judicial notice. Uganda should not, they must be signed, satisfied by the competent authority, by the competent authority. So Uganda uh, should carry what we call a judicial notice to take the document as already proven. To take the document as already proven. So thank you for watching. I urge you to share